Hello, everybody. Uh, it's a pleasure to meet you all virtually. I'm Tracy Hester, professor at the University of Houston Law Center, and I co-direct our Environment, Energy, and Natural Resource Center with Professor Gina Warren, who is also a former UH Energy Fellow, and try to keep track of issues arising at the intersection of environmental and energy law. In the past, we've kind of watched the two slowly merging together. Now it seems like energy law is shaping different ways of approaching law and regulation in ways that will spill over to environmental. One of them is tort liability for climate change, our topic for today. So I think if I had to just be, can I give you the quick, hold on one second to get this to work? Yes, there's are lots of things going on. I imagine many of you on the front lines are seeing them. For example, as we've seen increases of events that are being attributed to climate change, such as increased wildfires, storm damage, sea level rise, changes in epidemiological profiles due to migrations of insects to new areas, there has been an increasing attempt to figure out how to anticipate and respond and tally up those damages, and then seek someone else who can help share those costs. And as we all know, a lot of that attention has turned to energy companies that have provided some of the fuels and other sources of energy that have led to greenhouse gas emissions. So, very quickly, big picture, where we're going to talk about today. And, I'll be honest with you, this is a huge, sprawling, active topic, which, quite frankly, we could spend an entire semester going into in detail. So, I'm going to try and just give a high level, quick snapshot with the idea that you should be aware that there's big events imminently on the horizon. Just in short version, though, this is not a quiet area. There is a lot of litigation actively underway in multiple areas, and I'll describe how we've gotten to this point and why we're the places that we're at. As part of that, though, that's all to lead up to the sort of the takeaway, which is that we are poised for a potentially transformative decision from the U.S. Supreme Court that may redefine the entire set of dynamics that have been driving this litigation, either to essentially open the pathway for more aggressive lawsuits or alternatively sweep the board clean. So first of all, I can't resist saying that I do sometimes feel like I'm a little too close to home and I tend to have a provincial outlook. We are talking about a global phenomenon. These lawsuits are being filed throughout the world in multiple different jurisdictions, and they're having different outcomes. We're seeing much more, for example, aggressive judicial activity in the UK, in Germany, in Australia, in Philippines. And for the energy companies that are at the crosshairs of this litigation, obviously they play in all those fora at the same time. So while I'm about to sort of spend most of my time on the United States, keep in mind that there's a much bigger picture. But having said that, obviously, the United States is got the location, jurisdiction, assets, sophistication. That's a very attractive forum, particularly in terms of what remedies can be ordered in response to this lawsuits. So in the United States, we've actually got over 30 different lawsuits filed in mostly state courts. I'll explain why in just a minute. This is a snapshot as of about an hour ago as to where all the lawsuits currently stand in different courts in different states. You'll notice a lot of them are blank. That is actually not an accident. I'll talk about Texas as a special example of this particular issue and how these climate tort lawsuits will not find fertile ground here. So for those of you who are interested in this area, want to know more about it, just a quick shout out. By far the best website for just raw information about what's happening, including all the underlying court documents. I highly recommend the climate loss litigation tracker that's maintained jointly by Arnold and Porter and the Sabin Climate Law Center at Columbia Law School. This is just the snapshot of the opening screen, but you'll see that it's broken down by statute, subject matter, and all those are live links that will take you to the underlying key documents, complaints, motion of summary judgment, and actual decisional documents by the courts. So with that in mind, let me lay the stage a little bit and give a little bit of a historical perspective as to how we got here, and then we can turn to what's afoot. This is not new litigation. They actually started over 20 years ago with lawsuits that were filed in federal courts and multiple jurisdictions. So we're talking about around 2006 to 2008. We saw lots of attempts to hold energy companies responsible for alleged climate damages using theories of tort, but all filed in federal courts under federal common law. I realize, at any point, if I start lapsing into something that sounds like English but is actually legalese, please, send me a chat message or let me know, and I'll make sure that I'm not disconnecting from everybody. But what's going on here is that, as you know, the United States has two layers of courts. One is the federal court system. We have district courts that sit in every state that then get appealed to the U.S. Federal Courts of Appeals and then to the U.S. Supreme Court. At the same time, every state has its own state court system that usually handles a parallel but different types of cases under state law. They too work up their own chain of appeals. For us, it's either the Court of Criminal Appeals in Texas or the Texas Supreme Court. And those decisions sometimes, but not always, can be appealed to the U.S. Supreme Court. Well, the first tranche of these lawsuits were all filed in the federal court system. And they're all filed not under a particular statute, but under something that's called federal common law. The idea is that courts can decide to impose liability, to make legal decisions based on just sort of body of law that's grown up over decisions over centuries. And tort law, the idea that I can hold you responsible for hurting me because you were negligent or that you did something maliciously, is one of those bodies of common law. Well, in the United States, in the federal court system, there is some space for federal common law. And that is a unique, solely federal body of law. The idea in these lawsuits was that we had three big lawsuits, all filed in different federal court circuits, all alleging in different ways tort liability for energy companies that had allegedly contributed to climate change. The three big ones, one was in the Northeast, and that was Connecticut versus American Electric Power, which went through the Southern District of New York up to the Second Circuit, then up to the U.S. Supreme Court, as we'll describe in just a second. The second one was actually here at home, the Comer versus Murphy Oil Company lawsuit filed in Mississippi because of damages due to Katrina, basically straight up property damages for people whose homes were basically destroyed by the storm. The allegation was that chemical companies, energy companies, cement companies, a whole array of companies contributed to the intensity of Katrina through greenhouse gas emissions. And then last, a lawsuit filed by an Alaskan village, you'll see a picture on the lower right-hand corner, which was being swept out to sea. This native Inuit tribe it's the native village of Kivalina, brought a lawsuit against ExxonMobil and a host of other energy companies, basically not asking for big climate damage money, not asking for injunctions. They were asking essentially just for the money to move their town. It was essentially a test case to lay the principles of liability down that would then lead to future lawsuits by other parties. Well, as these are working through the courts, basically a few quick observations. The district trial courts, the judges who first heard them, all dismissed them. They thought they were terrible ideas for multiple reasons. But when they were appealed, every single appeals court was receptive and reversed the district courts and said that these cases could proceed in federal court. Until finally the United States Supreme Court stepped in at Connecticut versus AP, and in a unanimous decision, the court held that there was no federal common law that could apply to these tort lawsuits. Why? Because when Congress passed the Clean Air Act, it gave EPA the capacity, the power to regulate greenhouse gas emissions. And whether or not EPA exercised that capacity, the mere existence of that statute, the simple allocation of that power, meant that the common law created by federal common law disappeared. It's called displaced, essentially evaporated like morning dew. So the case got dismissed. The other two cases in the Fifth Circuit, the Ninth Circuit got dismissed. And essentially, everyone laid down their pads and went home. But there was, in the Connecticut versus AP, a very small paragraph and a footnote, which noted that this was solely decided under federal common law. But remember, I had said that there were two layers. There was still a possibility for state common law claims. which could be brought in state courts. And the Supreme Court specifically noted in Justice Ginsburg's opinion that they were not deciding that issue. So, of course, eventually people picked up their cudgels and went back to court, but this time to state courts. And starting in 2018, we had a wave of new state tort lawsuits filed in state courts by an array of local governments, trade groups, cities, states. They all alleged the same sorts of tort claims we saw in the first wave: nuisance, negligence, strict liability, but they also sought money, compensatory damages, injunctive relief, but they also added a new twist. They also alleged that the companies were responsible under tort because essentially they misrepresented their products. Essentially, a product defect. They sold their products without warning their customers that using them could contribute to climate change in a way that might hurt the customers. And as a result, that is a harm that arises from the representation directly to that customer. It's not something that relies on this intermediary climate change global process. It strictly takes place within the boundaries of the state, according to the states. So as a result, these new state climate tort lawsuits were engineered effectively to try and sidestep some of the same aspects of climate change that led the Supreme Court to dismiss the first wave. So with that in mind, things have gotten very interesting. As you might expect, we've had full-scale scorched earth litigative warfare over these state tort lawsuits. I'm skipping a lot of intermediate litigation, including 2 separate appeals to the U.S. Supreme Court. Most of that was basically procedural wrangling over where these cases should be heard. Should they be in state courts or should they be removed to federal court? Hold that thought that basically, as of about until last week, the answer seemed to be generally that almost every single attempt to remove these to federal court failed, and they got remanded back to state court. We've had separate decisions since those remands, which some of courts have said that these cases cannot proceed, that they're basically preempted, which I'll talk about in a minute. For example, Maryland Supreme Court recently ruled that. Other courts have said, please go ahead, including the Colorado Supreme Court. So we've seen a split developing among the state courts and different jurisdictions, which would invite the Supreme Court to step in. At the same time, we've seen attempts to kind of jump to the front of the line, skip this slow baking process. 2 of them are pretty startling. One of them was an attempt by a collection of states' attorneys generals to basically knock on the door of the Supreme Court and say, hey, skip the appeals. We want to come straight to you. You will be our trial court. And we want you to decide under your original jurisdiction to decide under the U.S. Constitution fights between states, state versus state. The Supreme Court hears those cases. They wanted to say, basically, these tort lawsuits are states suing in a way that basically takes on and violates the interest of other states. So we had a very rare attempt to invoke the original jurisdiction of the U.S. Supreme Court. And the court, in response, didn't just dismiss it out of hand. They asked the U.S. Solicitor General, the chief lawyer of the United States, to weigh in. It seemed to be taking it very seriously. That Hail Mary, however, was rejected by the court last year, but it's still something that is being kicked around in different jurisdictions as a possibility. At the same time, we also saw the Trump Department of Justice file 4 different lawsuits to essentially preempt, to stop these lawsuits in their tracks before they got any further in the state courts. In particular, they filed a lawsuit against Hawaii and against Michigan, alleging that these lawsuits cannot proceed. In addition, they filed 2 other lawsuits against New York and Vermont, trying to stop them from passing passing legislation that would effectively create climate superfunds, which we'll talk about in a minute. Basically, at this point, all those lawsuits have either been dismissed or been unsuccessful for various reasons, such as it's just simply too early to have these lawsuits. But it shows that the Department of Justice under the current administration is prepared to step in and take extraordinarily unusual active steps to try and stop this litigation before it gets much further. So as you can see, we're kind of lots going on, all different places. And so, of course, there's got everyone's attention when the U.S. Supreme Court decided finally to step in substantively. We now have a case that is pending before the U.S. Supreme Court, Suncor Energy versus Board of County Commissioners of Boulder County, which essentially squarely tees up the question whether these state tort lawsuits are essentially preempted by the federal laws, be it because of the Clean Air Act or just because the U.S. Constitution says states can't meddle in interstate activities, and climate change and greenhouse gas emissions are inherently interstate. So it's interesting in that the court granted this petition for review. It's called petition for certiorari, but they did it for two questions, not one. The first question is the one I just described. Are you preempted? That sort of sweeps the chessboard clean, go back to square zero. The second one was, interestingly enough, should the court be hearing this case? There are some concerns as to whether or not that it had gotten far enough because there's been no trial verdict yet saying someone's liable. Is it too early to have this Supreme Court weigh in? So we have an interesting grant of cert at the same time, a question that seems to imply, well, maybe we shouldn't grant cert, which means the court's wrestling with this issue. But at this point, right now, we are poised to have briefings and preparations for oral arguments to take place in the very early portion of the October term in this fall. If that happens, we can reasonably expect a decision by maybe the end of this year, but more likely early next year, which may just completely redefine the terrain for these lawsuits. Stay tuned. Now, in that regard, something else has happened in the background. Actually, a couple of things. But the most important one, that's the most notable, that changes the calculus for all these lawsuits, is the idea of whether the EPA has power to take action on climate change issues. Remember I said that the whole displacement issue of federal common law and the whole preemption issue is based on the idea that Congress gave EPA the power to deal with climate change, even if EPA chose not to exercise it. And that granted power essentially kept federal common law from arising and essentially pushes state laws to the side. Well, EPA, in a pretty monumental step, frankly, decided that they were going to step away from using the Clean Air Act to regulate climate change. With a lot of history here, which we will unfortunately skip over, but if you have questions, I'll be glad to discuss at the end here. But basically, after the U.S. Supreme Court, Massachusetts versus EPA, long ago, the Supreme Court in that case said, yes, EPA has the obligation to decide whether or not it needs to regulate greenhouse gases based on whether or not it posed a threat to human health and safety. That basically meant that EPA clearly had the power under the statute to step forward and do it. That led EPA under the Obama administration to issue what's called the endangerment finding, which basically finds that climate change does endanger human health and the environment, which opened the door to mandatory regulation of automobile emissions, as well as a cascade of other endangerment findings under other parts of the Clean Air Act that all led to actions to regulate greenhouse gas emissions. The big change, which I mentioned before, which I've referred to, happened this year, just a couple of months ago. EPA decided to revoke the endangerment finding. Basically, they're kicking out the base of the pyramid for all other climate regulations that rely on it. The basis for revoking the finding, though, was not because they've got better science or that the facts have moved. In fact, EPA attempted in its proposed revocation of the endangerment finding to say things like that, and they backed away from that and instead decided to rely solely on the legal argument that they've reread the Clean Air Act and they've decided, well, the better reading under new case law from the U.S. Supreme Court is that we don't have the power to regulate greenhouse gases. That is obviously hotly litigated right now. It, however, means if EPA and the Department of Administration prevails in this argument, the endangerment finding will be successfully withdrawn, which means EPA will not have the power to regulate greenhouse gas emissions under that portion of the Clean Air Act. So it's a delicate dance. EPA wants to take this superstructure off the table to regulate greenhouse gases, at the same time without opening the door for these lawsuits to be revived or to not be preempted. That delicate dance is underway. Right now, we've already seen, let me show you this real quickly, filings in the Suncor Energy case before the Supreme Court that basically try to walk this line. And the amici are specifically, I've highlighted one of them from the United States itself. The briefs and the amici briefs are all emphasizing that this sort of can you preempt or displace other fields of law when you don't exercise that power and, in fact, actively disclaim that power is the issue the court will likely have to squarely deal with. So we're all very keenly interested in this. Expect this is just the amici briefs for whether the court should hear the case. It's going to be a blizzard of activity over the summer with parties attempting to file statements and interested parties filing statements explaining why the court should or should not grant the petition to determine that these cases are preempted. Now, that's just the lawsuit on climate tort liability. And I know that's what I promised to talk about. But I wanted to save a little time to also point out there are other games afoot that could affect this. Very quickly, we're seeing legislative activity, and that's at the state and federal level. On the state level, we're seeing multiple bills being filed to essentially say, by law, you can't bring these lawsuits. Most importantly, Utah, Tennessee, and Indiana have enacted laws or are finalizing laws to preempt local climate damage claims. What this slide doesn't say, and is actually something that has deep roots, Texas occupied this position over a decade ago. It passed its own law saying that if you've got a clean air permit, and that permit could have regulated greenhouse gases, like, for example, carbon dioxide or methane, you have an affirmative defense that protects you from liability from any tort lawsuit. So there's very strong activity from different conservative lobbying groups, including the American Legislative Exchange Council, to sort of create this network of state lawsuits that would preempt these types of state tort law liabilities. At the same time, very recently, we've had bills introduced in the House and the Senate that would do the same thing federally. This is obviously high-stakes lobbying. The bill in the Senate was introduced by Ted Cruz. It's so recent that when I checked this morning to get copies of the legislation, it still hasn't been posted by congress.gov yet. So we're waiting to see how that develops, but obviously that's going to be extremely high-level activity. It's going to be buttressed and influenced by the continuing stream of high-level executive orders from the Trump administration, emphasizing the priority of energy and specifically saying that these lawsuits are against the national interest and should not prevail. With all that taking place, obviously, if Congress rules that these actions, Congress deems that these actions are by statute not permitted, the case before the Supreme Court likely goes away. So I mentioned a few other things. This is just such a fast-moving field. The U.S. Supreme Court on Friday, last week, handed down a decision which may affect all of this. It deals with the case some of you may be following, Chevron versus Plaquemine Parish, excuse me, which dealt with whether or not energy companies could be sued for damages that they had caused from energy production that had led to degradation of levees and waterways and enhanced climate change issues. The energy companies there tried to do the same thing I described with the tort lawsuits. Get me out of state court, remove me to federal court. And while it was rejected uniformly with the climate tort lawsuits, the U.S. Supreme Court, and the surprising decision, actually granted the motion to remove this case to federal court, saying that Chevron and the energy companies were basically acting under contract with the U.S. government by providing fuel to the military, and that therefore this case should be held in the federal removal statutes in federal court. That may cause a rethink on whether or not these climate tort lawsuits should be removable to federal court too. We have other things happening in the sidelines that could be affected by the U.S. Supreme Court's decision, one of which some of you may be following, the idea that the youth plaintiffs have been following that there's a constitutional right to a clean and stable environment and climate, which has been, frankly, uniformly rejected by almost every court in the United States so far. But this lawsuit is still actively underway in the Ninth Circuit. We're also seeing lawsuits being filed. Remember, I said it's a worldwide phenomenon, being filed outside the United States in other courts. For example, this is the picture is of the plaintiff in a lawsuit that's currently filed in Germany, where a Peruvian he does multiple things, but essentially is a subsistence he tour guide and subsistence farmer in Peru, is sued claiming that climate change has made the glaciers and the lake above his home unstable and that he is at risk of being of grave harm if they had a flooding event or if the water level changed. That lawsuit's actually proceeding in Germany, and if it results in a verdict, could be enforced in another nation. It's relatively easy to bring a lawsuit in another court, and when you get the judgment, if it's a dollar amount, you can turn around and then recover that dollar amount in another court system without relitigating it. So that means if someone, for example, wins a lawsuit in, let's say, for example, Bolivia, and that lawsuit's against a U.S. company, and it results in a judgment, a money judgment, that money judgment, in theory, can be relatively readily enforced in the United States, with the United States courts essentially accepting that verdict as long as it meets certain basic fundamental notions of justice. Now, you'll notice I'm using some very cagey language here. We've seen lots of these lawsuits being filed, but probably the one that sort of is the best lesson for what could happen was actually not a climate case. Many of you may remember, though, that Chevron was actually sued in Ecuador by a collection of indigenous tribal members, alleging that the company's operations had caused environmental damage and oil pollution, and was not cleaned up when Chevron left the company and transferred its estates to the Ecuadorian, basically the Ecuadorian Petroleum Company. What happened in that, though, was not the original verdict, which was handed down in Ecuadorian court for billions of dollars. What happened was the attempt to enforce the United States led to a cascade of, let's just say, sobering lessons about how you can enforce these judgments. Many of you may recall that the Southern District in New York refused to enforce that judgment. They said that it was infected and rife with fraud, and actually enjoined its enforcement by any other court in the United States because it was a violation of RICO, the Racketeer Influenced Corrupt Organizations Act. Attempts to enforce it in Australia and in Canada, and even the nation of Grenada, have all essentially met similar ends. So while what I've described to you is the sort of status quo, the default nature of the system, the Chevron case highlights just how difficult it can be in certain cases, particularly large politically charged ones, to actually carry through. We're also seeing attempts to rephrase that. Attempts to influence the way these transnational lawsuits take place by nations passing model statutes, which make it easier to bring these cases and enforce the verdicts in other nations. We can talk about that if folks are interested in the Q&A. So looking ahead, I want to sort of make sure we didn't overlook. Remember, I said that the Trump administration had filed 4 lawsuits, and of the 4, 2 dealt with a new type of state legislation called climate tort superfunds. The idea behind these is that it's not an attempt to ascribe a share of responsibility to an energy company for climate change damages that its emissions or its products' emissions might have caused. Instead, the idea is it simply notes that climate change is causing damage to a state's economy and infrastructure. It then tallies an amount that could be ascribed to that damage, and then it has a legislatively determined share or ratio that can be assessed against companies that operate within the state to help pay for that infrastructure damage. That climate tort superfund statute has actually been passed in Vermont and New York. So it's a direct liability. It sort of short circuits a lot of the scrambling and fighting in federal court over who caused what. But it faces the same sorts of challenges as these tort lawsuits. Are they preempted by the Clean Air Act? Is it unconstitutional to essentially try to impose retroactive liability for emissions that took place 100 years ago, theoretically, that are causing damage currently in those states? Small side note, Similar challenges were raised against the federal Superfund statute, and none of them prevailed. We can talk about why if folks are interested. Is it a violation of due process? And more, one that's interesting that did not pop up in the federal Superfund statute, is it an intrusion into the federal government's foreign affairs powers? The United States, and particularly the president, is the sole organ for representing the United States interest abroad. Do states unduly meddle in that sort of protected sphere when they pass statutes that impose liability for emissions that are, by definition, global, and also tend to involve other parties who are resided in other nations? It's hard to imagine a suit like this proceeding without involving someone like BP or Total or Saudi Aramco or other, in particular, sovereign national energy companies. So right now, current state of play, these statutes are passed. They're law. They're in the process of being implemented. They're drafting the regulations and figuring out the formulae that will be used to allocate the amount of money the companies will pay. And there is a ton of litigation over whether or not these laws are going to be preempted. But right now, the states are moving ahead, and other states have expressed strong interest in taking a similar approach. Here's just a quick look at what the state of New York legislation looks like. Notice it begins with extensive legislative findings to sort of lay the groundwork as to what facts the courts are going to have to defer to for legislative determinations. So that's the big picture. Sort of takeaway for everyone, and I'm looking forward to talking with you, is after decades of litigation over what could potentially be some of the biggest lawsuits in U.S. history in terms of potential damages that are in play, we may finally have an outcome at the U.S. Supreme Court which determines which way these lawsuits are going to go. And it will be interesting to see, because this is not going to fall on the usual polarity we expect. This is a lawsuit that is going to involve, it's not a climate change lawsuit, it's also a states' rights federalism lawsuit. To a certain extent, the issues are not going to turn over grand schemes of constitutional power. They're going to turn over, how do you parse and interpret the language of the Clean Air Act in a way that gives due deference to the powers and responsibilities of states in our constitutional federalist system. And as part of that arrangement, when you're trying to assess that, we're talking about essentially the ultimate major question. The Supreme Court has had what's called a major questions doctrine, which says you can't attempt to regulate something unless that's major, unless Congress has given you a clear expression in a statutory language that it wants you to do that. Well, here it is very clear that the Clean Air Act does not specifically clearly address the issue in the way that's being postured in the current Supreme Court litigation. So to a certain extent, we will see whether or not the major questions doctrine works both ways. It's been used to effectively shut down attempts to exercise regulatory power based on ambiguous statutes. Does that apply the other way when someone's attempting to essentially use a statute that doesn't expressly address it to preempt state law expressions of power? So with that, I'm happy to start taking bets, but that's going to be a hard one to predict. So with that, I'll turn the mic over, Debelina, to folks who might have questions or want to talk.